So my name is Rebekah Case. I'm an associate at Zaparas Lawyers. I work in the Transport Accident Department doing claims for people who've been injured in transport accidents. I also have a small number of public liability claims, so people who've been injured on the sidewalk or in the shopping centre. The TAC can pay for a number of things. First of all, we've got the no-fault benefits. So what we do most commonly is deal with trying to get people's medical and like expenses paid for. So physio, visits to the general practitioner, that sort of thing. They can also pay for your wages, and there's a small lump sum. Those are no-fault benefits, so irrespective of how the accident happens, you can be entitled to those things. Secondly, there's what we call a common law claim. Now, common law claims are available when we can prove two things. First, that you've got a serious injury according to the statutory definition, and secondly, that the accident was partly caused by a third party. So the bulk of what I do is trying to obtain a client's medical and like expenses for them. These are expenses that can be paid by the TAC as long as they are reasonable and related to the transport accident injuries. There's no definitive list of what you can get under this category. It's very, very broad. So the usual things are trips to the doctor, physiotherapy, hydrotherapy, pain management programs, that sort of thing. Additionally, that can extend to things like mattresses or walking sticks. I had a client who had a baby, but because of her back injury, she couldn't reach down to put the baby in the pram, so the TAC can fund a pram that came up to meet her. They're not going to, I've also had a client have modifications to the car, and they're not going to buy a new car, but they will pay for the modification. So she had a leg injury and couldn't use an automatic car, but the TAC paid for the modifications. So to get treatment paid for, a client needs to speak to their medical practitioner about what they need. That medical practitioner then needs to write into the TAC and request what the treatment is, preferably with reasons why. Lawyers can't actually do this because we can't justify the treatment on medical grounds. So once the request goes in, the TAC will send a form letter saying that they've got the request, and then they'll then consider the material on file and make a decision. Sometimes, depending on the nature of the request, it might go to the clinical panel. A clinical panel is a board of medical practitioners at the TAC that will consider the request. Most commonly, it's surgery that ends up at the clinical panel. The chances of having something approved by the TAC can be greatly enhanced by having legal representation on your side. Additionally, this is something that Zaparas Lawyers does for free as part of your claim. We don't bill separately for this. So if you've got a claim with us and the TAC has denied some treatment, we're more than happy to dispute it for you and chase up until the TAC makes a decision. So there are some treatments that don't require a written request being sent into the TAC. When you lodge a TAC claim, they'll send you a letter and outline a few treatments that they will give preemptive approval for. So those are things like radiological investigations and some physiotherapy. So the TAC may stop treatment for a number of reasons. Most commonly it's because the treatment period has expired. So if you're getting physiotherapy, they won't pay for it indefinitely. What they'll do is give you, for example, 12 sessions over 3 months. When that 3 months ends, the TAC will stop paying for physiotherapy. What you need to do then is, before the end of that period, get a new request in and make sure it's approved so that you can keep continuity of treatment. The other reason that the TAC might stop treatment is because it's become what they term maintenance treatment. So the TAC is happy to fund things if it is improving your condition or preventing a deterioration, but as soon as it becomes maintenance treatment and it's only really making you feel better for a little while and then taking you back to your normal state, that's maintenance treatment, and they'll stop that because it's not considered to have made a functional improvement to your life. If the TAC stops payment for treatment, we can dispute that decision for you. The first thing is to go take the decision letter to your lawyer, and we can talk about the reasons why it's been ceased and why you need the treatment continued. Our office can then issue what's called a dispute application with the TAC, and we'll exchange documentation back and forth. Usually we'll need to get a letter of support from your medical professional who has recommended the treatment. And then we'll have what's called a pre-issue conference. So we'll sit down with the TAC and argue your case for you and try and get the decision overturned. If we're not successful at a pre-issue conference, we have the option to proceed to the Victorian Civil and Administrative Tribunal. It's rare that we would need to do that, but it is an option if we can't get the TAC to change their mind. And that's why it's important to see a lawyer as soon as possible after your accident. These processes are complex and there are important deadlines that must be met. At Zaparas Lawyers, we do these sort of disputes every day. We're extremely familiar with them and they're done for free as part of your claim.